Mr. Fildebrandt was obviously disappointed. This is a regulatory offense. It's a traffic offense. The offense consists of failing to leave a note or notifying an owner of a collision. The Crown only had to prove that there was a collision and that he was involved in the collision, which the court was satisfied took place on that particular date. So Mr. Fildebrandt, acting upon the belief that he had not been in an accident, had simply not left a note. Again, we have to remember that this is not a criminal code offense. This is a matter of a fine associated with a traffic safety offense, which he will pay today.
So you told the court, I've got 22 witnesses who can say I wasn't there at the time. Yet, as the judge pointed out, you never presented any of those witnesses. Why not?
The difficulty is that in these A&P meetings, nobody kept roll call. And there was no record of who was there, at what time people would arrive, at what time they would leave. In the absence of documentary evidence, or in the absence of someone having a specific memory of that date, June 16th, it was difficult, or June 6th, I'm sorry, 2016, it was difficult to find someone who said, yes, I remember that specific date, and I remember him sitting in that meeting. People were saying, well, he was usually at that meeting. We normally had him there. And it's like the judge said today, he gave evidence as to his routine, which most people in similar circumstances would have done the same. This is what I normally do on that type of day, but unfortunately no one had calendars, no one had notes, no one had specific recollections of that day. It is conceivable that he didn't know that the accident took place, and afterwards was convinced that it hadn't because he had backup sensors in the vehicle, he had warning sensors, he had no damage on his vehicle. Why would he consider that he was in fact in an accident?